Hello, my name is Rita Amarichinda. Welcome to #IP series, where we talk about recent intellectual property cases and development globally. As we know, IP is everywhere, and this could take the form of trademark, copyright, patent, industrial design, geographical indication, trade secret, plant variety, and biotech. If this is your first time listening to IP series, please favorite my podcast on Anchor. On this episode, I have with me is guest who I have followed her work since 2013 while I was doing my LLM. She is a renowned IP practitioner with specialty in copyright and a 2020 WIPR Influential Women in Intellectual Property. If you're creative, get out your notepad and start taking down notes, because this particular episode is full with a lot of germs. So stay tuned, guys, as we welcome our guest. Cheers. Welcome to IP series, Eleonora. Could you introduce yourself? Just tell us a little bit about yourself.
Of course. Hello, everyone. Thanks so much, Rita, for having me as a guest in your podcast series. My name is Eleonora Rosati. I am an Italian qualified lawyer, and currently I am an associate professor in intellectual property law at Stockholm University in Sweden, as well as an off-counsel at the international law firm Baird & Baird.
Fantastic. And you were also nominated this year as a 2020 WIPR Influential Women in
Yes,
IP.
like yourself. It's a great company.
Yeah. Okay, so what is copyright to you? What do you, in layman's terms, what would you say is copyright?
Of course, the academic answer is that copyright is an intellectual property right, which has as its object of protection creative works of the mind. So, for instance, books, paintings, music are all protected by copyright, but also other things such as databases and computer programs, which may seem to have little in common with art as we think about it, are also objects protected by copyright. Unlike other IP rights, copyright protection arises automatically. So this means that there is no need to undertake any formalities or register your work. It will be automatically protected upon fulfilling the relevant requirements, notably the one of originality. Originality is a requirement that governs copyright law, and I guess that it is difficult to understand what originality means also in lay terms. So, for instance, when we say that someone or something is original, what do we mean? Something never seen before, something a bit peculiar, something creative. So these difficulties that we find in everyday language become even greater when this becomes the legal test to determine whether there is indeed a valid copyright or not. And these challenges are well visible in cases that are decided all the time in every part of the world.
Fantastic. So what is the interplay of copyright and intellectual property?
But the interplay, I would say, is well visible in the fact that different rights can subsist in the same object simultaneously. So, for instance, there is nothing that prevents the same object from being protected by copyright as a work and be registered as a trademark or be subject to design right protection. So the interplay that you refer to, I think, must be also seen in light of the fact that there is this principle of cumulation of intellectual property rights, which is used not just to extend the intellectual property life of an object, but also to protect different things in relation to the same object. So, for instance, just to make an example, you might have an artwork like a sculpture that is protected by copyright, but if that sculpture is also perceived as an indicator of commercial origin, then potentially it might be also protected by a trademark registration. The object of protection between copyright and trademarks is the same, but the extent and characteristics of the resulting legal regime are different because different are the goals and rationales of protection.
What would you say is the impact of COVID-19 in the copyright sector? You know, the year started well, and then from March there was a global lockdown because of the pandemic. How did
But
the
I think
pandemic
that
affect
the
copyright
impact of the
sector?
pandemic has been felt in several areas. Certainly, it has affected both individuals and companies. A lot of focus has been on the patent discourse around the vaccine, etc. But of course, also stakeholders in the copyright field have been greatly affected. And I would like to draw your listeners' attention to 3 key points, which I think have emerged with significant strength over the past few months. The first one is that, of course, being in lockdown means that you cannot go out. And this means also that performers cannot perform in theaters, concert halls, and this has greatly affected the incomes and the very livelihood of many artists, musicians, actors, etc. Just to give some data, UK Music has estimated that during the course of 2020, UK-based musicians have lost 2/3 of their overall revenues. So this is a significant and severe impact, which shows also the importance of live performance for the overall revenues of artists. The second point is the rise of live streaming. So we have seen more and more artists perform live through social media, live streaming from Facebook, Instagram, etc. And this is something that has been done to create some sort of proxy with the real life experience of performances, recitals, recitations, etc. And then the third point, which affects the movie industry and has the potential to unsettle this industry in the long term, is the recent announcement, which I'm sure you have seen, by Warner Brothers, that they will be releasing their 2021 films simultaneously in cinemas and HBO Max. This is a major shift because indeed it changes the distribution model that has dominated the movie industry for decades. The so-called windowing, in which you have a film that is first released in cinemas and then after a few months is released in other formats, first video cassettes, then DVDs, and now streaming platforms. By removing this window, you are making a major shift in the distribution model, and I think that this shift is likely to remain also after when the pandemic is over, and I guess that this will have significant repercussions both in the lawful exploitation of content, but also in piracy. Sometimes we hear the consideration that people engage with piracy because they don't find the lawful content. The film that they want to watch is not yet available on streaming services. And the fact that now the right holders will distribute right away their content also across streaming platforms might mean that the incentive to consume pirated content might decrease even further. So this will be an interesting point to monitor over the next few months, and I would say also over the next 2-3 years.
I totally agree with you. So what would you say is like the fusion of tech with copyright related works?
But I think that this is a trend that started a while ago and will continue. So technology is, I would say, the natural companion of copyright. Since its very inception, copyright laws have been challenged with technological advancements. And if we think also about the relatively recent history of copyright, we see that these challenges have been dominating the discourse. Just to give some examples, I guess that your listeners will promptly remember the litigation that took place in the US and eventually reached the US Supreme Court regarding VHS recording and the legality of all this. Then the issue with printing machines, now more recently issues with linking and online platforms. So I guess that this will continue being topical because it is part of copyright's DNA. Something, however, that I feel is important to highlight and is a more recent trend which we find across different industries is the importance of data. Data mining exercises, text mining exercises that are undertaken also for predictive purposes. So, for instance, we see that the content that we share through our social media, the emotions that we express through our likes, dislikes, loves, surprise buttons, etc., serve to give information about what we want. And I think that the importance of data will be dominant over the next few years. And we've seen already that these data mining exercises are done by copyright-intensive industries to predict and anticipate trends. So, for instance, now movie studios invest in the financing of a movie if they know that already it will be a success. How? Thanks to the type of information that we as social media users disclose. The same is done in relation to record labels. They sign new artists in certain fields when they know that consumers will want to hear more from the hip-hop galaxy vis-a-vis rap, vis-a-vis trap, etc., etc. And the same is done also in the fashion industry, and all the industries that rely on creativity also increasingly use data. And I think that this is a major trend that will become even more intense over the next few years.
What's your best copyright case for 2020 or 2019, 2020?
That is a difficult question because of course, like you will appreciate, all every copyright case has its own points of interest, so it is difficult to identify the best one for 2020. Probably the best case is always the one that has not been decided yet. When you think about what will happen, our court will think, there is always this anticipation that elicits a lot of thoughts and reflections. But on a more serious note, I would say that the best copyright cases of the year are those that do not relate to anything new. They relate about things that are old. So no internet issues, not platform issues, but about things that perhaps we had not thought about and we are compelled to think about. I shall make myself a bit more a bit clearer by highlighting these cases. The first one was a case litigated in Europe in which the question was that whether the provision by a rental car provider of cars with radios installed therein would be something that required a license from the copyright owners. The other case was whether the provision of evidence in court of copyright protected content would be subject to the control of the owner of the copyright in the image that was produced in evidence. So these two cases, both litigated in Europe, both eventually reaching the Court of Justice of the EU, which is the highest court in the European Union, show that questions about copyright are not fully explored yet, and even analogical cases like these that have nothing to do with technology, have nothing to do with the internet, suggested to me that indeed the copyright is a very live subject, and we don't yet know everything about it in the offline world, let alone the online one. So this will be my pick, because there are cases that tell us that there is still a lot to learn about these inherently flexible but very complex intellectual property right.
So what would you say is your most controversial copyright case for 2020 or 2019, 2020?
I would say probably a case that has a long standing impact, but was not surprising to me, so I will not indicate it as controversial, but to some it has come a bit as a surprise, is a decision from 2019, September 2019, of the Court of Justice of the European Union, which ruled on the copyright protection of designs. Now, as you know, this is a long-standing issue in copyright. It is one of the topics that students of copyright law engage with, and there are many cases. But in this decision, the Court of Justice clarified that the only standard that you need to take into account is the originality of the design and not other issues such as whether the design has aesthetic merit, appeal, is artistic. And this goes against the tradition of many countries which, for protection of designs by copyright, have indicated the need to fulfill indeed this very criteria. So the decision of the Court of Justice in this case, it is COFEMEL, is not surprising, so I will not call it a controversial case, but it came as a confirmation that in Europe there is a very active, if not activist court, and this suggests that European countries need to be more uniform in their approach to copyright concepts and principles than perhaps they thought they should be when the harmonization of copyright laws in Europe began a few years ago.
So what are the trends you think we should look out for in the copyright industry?
But I would say that the major trends are those that I've already hinted at. First one, data. There will be an increasing investment in data, and companies will invest in technologies that allow to mine large quantities of data in order to detect and anticipate and satisfy trends. So this is something that I think will boom even more in the years to come. The second trend is something that we are seeing across the world in different jurisdictions, and it is a discourse around the fairness for copyright stakeholders. So in Europe, I'm sure you will be aware, last year there was legislation being adopted which was meant to create a rebalance in the position of power between different stakeholders. On the one hand, authors and performers vis-a-vis companies such as publishing houses, record labels. On the other hand, press publishers vis-a-vis information society service providers, and copyright holders vis-a-vis online platforms. And this trend is likely to continue because in Australia currently there is a discourse around whether press publishers should receive greater protection in the form of copyright legislation. And in the US, just a few months ago, the US Copyright Office released a study on the functioning of the US safe harbor system. And the ultimate recommendation of the office was perhaps to open a discourse around whether the existing legislative framework is fit for purpose or whether instead a reform is needed because of an alleged imbalance that has come to appear over the past few years. So this is a trend that we are seeing around the globe, and I think that it will continue in the context of 2021.
Interesting. So what is the best form of intellectual property
That is, a tough
protection
question
for
because it
creatives?
depends a lot on what you do as a creative. It is, of course, a very broad term that might encompass different types of creative actors. But I feel that for those who work in the creative field, copyright is a very good ally, and regrettably, it has been considered some sort of Cinderella right for many years. But now I think that there is increasing awareness of its importance and also its inherent flexibility. The fact that you don't need to register a work to enjoy copyright protection, it arises automatically, and it is a right with a broad scope and long duration, will contribute to draw attention to its also strategic relevance. The other type of right, which I think is important for creatives to consider, is trademark protection. Trademarks, of course, are useful for different reasons than copyright. They serve to protect indicators of origin, but there is an increasing tendency around different jurisdictions towards allowing registration as trademarks also of non-conventional signs. By conventional, I mean words, logos, etc., and instead allowing registrations, though of course it is not always easy to do so, of patterns, shapes, sounds, smells. So I think this is an avenue worth of deserving of further exploration, because again, a trademark is a pretty powerful IP right, and can be used to complement, if not to supplement, in certain cases, copyright.
So, what are the issues that you feel creatives face that are copyright related?
I think that this question is closely connected to another issue, that is that of contracts, no?
We can just take it together, the importance of contract and documentation.
Indeed, the reason why I'm saying contracts is the following, that if you think of individual creators, often they find themselves having to enter into contracts with much more powerful subjects, companies, big companies, and there is a natural imbalance that I guess translates to a contractual imbalance. Often we have creatives agreeing to terms that are really unfavorable to them, and so I think that ensuring fairness in creators' contracts is a big issue. The other big issue is that of documentation, which you mentioned, because of course copyright is a non-registered right, so one might not think about the importance of documenting step by step the creative process, because one might think I don't need that, but then as a matter of fact, when you go and enforce your rights, having evidence of what you have done is really key. And to this end, if you agree, Rita, I would like to draw your listeners' attention to a recent tool that has been developed by the World Intellectual Property Organization. It is a WIPO proof, which might assist creators also in documenting their creative steps, the works that they have, the versions of the works that they've created. And I feel that something like this might be really helpful also in assisting individual creators or small companies that own copyrights.
Fantastic. So what is the best form of resolving copyright related
best form? I don't think that there is a single answer. It depends on the situation. Of course, litigation is the nuclear option, if you allow me to say so. The problem is that, of course, one might not always have the inclination to bring judicial proceedings for a number of considerations, and also it is a matter of time, cost, and uncertainty of the outcome. So litigation is something that is there, but is not the only tool that can be used. I find that in recent years, another avenue that has emerged as being particularly useful to individual creators or smaller companies is mediation. There are different services that provide mediation experts to assist parties in a dispute, and these might be particularly useful. Another point which I would like to highlight is the fact that when it comes to copyright, often we are individual creators thinking that someone has infringed their copyrights, and then not fully realizing that what copyright law does protect is not ideas per se, but rather the expression of such ideas. So often we hear individual people saying, this person has written a novel that rips off mine. It is the same story based on the same facts, etc. But, you need to be very careful before, throwing accusations of this kind, because indeed, when it comes to the scope of copyright protection, as I said, it is very broad, but it's not limitless. And one needs really to show not only that there has been a copying of one's own work, so direct access to the work, but also that what has been taken is actually protected. Because if one only copies ideas, facts, intuitions, this might not be enough to sustain a copyright infringement claim.
Great. So what are your final words and advice for creatives, IP practitioners, enthusiasts, and all the relevant stakeholders?
I think that is a great question, which is very difficult to answer. As a common ground, I think that copyright does protect creativity, and those involved in copyright must be equally creative. So, for instance, when it comes to individual authors, they need not to be shy of breaking new ground, coming up with different solutions. We've seen a lot of creativity booming in the course of the pandemic, and despite the sadness matching these past few months, I think that we have seen new trends emerging, new ways to connect emerge, and so I think that it is important to bear in mind that indeed the ultimate goal of copyright is to safeguard creativity. And then when it comes to practitioners and those working in copyright law, advising creators, authors, performers, I feel that from our discussion, it has emerged that there is not really one size fits all rule. The specificities of each and every situation need to be taken into account. And so it is important also for lawyers to be creative in order to find the solution that works best for their clients. And as a final point, I think that for those wishing to work in copyright, so students of intellectual property, junior practitioners, those interested in a career change, I think that there is, encouraging data coming from the copyright field. This is an area of the law that has been booming, if I may say so, over the past 4 to 5 years. And we've seen a lot of activity at the policy level, judicial level, and also case law level. And this means that there is an increasing awareness of copyright as an intellectual property right, an increasing interest in using copyright to protect one's own creativity. And of course, I would be very interested to hear your views, but from what I read, also the Nigerian creative industries have become increasingly active. I'm thinking, for instance, of the music and movie industries. And this is a testimony to the fact that creativity needs to be safeguarded. Copyright can be a tool in this respect, and also creating increasing awareness in the general population and among consumers about the importance of respecting third parties' rights are all part of the same ecosystem in which creativity is protected, exploited, and safeguarded. By exploited, I mean that creators are able to do or authorize third parties to do the activities that copyright law does restrict.
And I think I agree with you as well. So from the Nigerian perspective, what we've seen, a lot of IP advocacy and awareness, because we had a lot of webinars going. So creatives were forced to sit down and listen to issues surrounding intellectual property, also understanding the business aspect of intellectual property. We had a couple of copyright related dispute judgments were given this year from the CMO perspective down to sync right licenses that were given, even though the compensation wasn't so much, but at least we have precedent. We also saw creatives coming. I know what is trending now is the social media call-outs, where you have creatives who would rather go to the social media to publicize their dispute instead of briefing a lawyer. So I think the awareness is growing by the day. The entertainment industry in Nigeria is also growing by the day, and we're hoping for a better 2021. We know a lot of live events and concerts were cancelled because of COVID and social distancing. But yeah, I think within the next 2 to 3 years, we should see more improvements. We are hoping our copyright law will be passed. What we're using now is so outdated, but I think with the cases that are currently ongoing and the awareness that is growing, I think things are going to get better.
Let's hope, and these, final words of hope, I think that indeed, as you suggest, should apply to anything. So let's look forward to 2021 as being, a more positive year, and that the good seeds that have been sown this year, are able to flourish over the next few months, because there are some good things that have been happening, and so it will be interesting to see how they develop.
So yeah, we've come to the end of our recording. Thank you so much.
Thank you very much.
In the copyright industry.
Thank you very much, Rita, for having me. It has been a great pleasure and an honor, and I look forward to seeing what the future holds for copyright and the creators who are at the basis of these industries and this area of the law that we all like to study, practice, and research.
And so we've come to the end of this IP series Christmas edition with Eleonora talking about copyright. If you learned something new, please send us an email to ipseriesinfo@gmail.com, or you can leave us a message on Anchor. Until the next IP series Christmas edition episode, cheers guys and happy holidays!